Here.
Two very short remaining points. I brought down this passage from Ultraframe, Mr. Justice Lewison, because my learned friend included in the bundle the case which is referred to on the last page of this photocopy, which is Mr. Crow's case, was sitting as a deputy. And it on the face of it, it is something which my learned friend can pray in aid because of the courts not interfering in the discretion of the directors, and it is a matter for the directors to consider what is bona fide in the interests of the company. And Mr. Snowden, in that case, counsel, emphasised it doesn't entitle the court to substitute its own judgment for that of the directors, and the good faith of the directors is decisive. And he refers then to a case called Regent Crest, which was Mr. Justice Jonathan Parker at first instance. But this Ultraframe case, and indeed the Regent Crest case, were cases of commerciality and management, and indeed Regent Crest was a case as to the waiving of a claim which the company had and whether it was in the commercial interests of the company. But Mr. Justice Lewison continues, the good faith of the directors is not, however, the be-all and end-all. If they act in good faith but for a purpose which is outside the ambit of their powers, their good faith will not validate their action. Similarly, if they act for a collateral purpose, their good faith will not validate their action. And then there's a reference to Howard Smith and Ampol, in which directors exercised a power to issue shares, but for the substantially, it was found, improper purpose of not gaining money for the company, but adversely affecting the percentages within the company in a contested takeover situation. And then his lordship says at 1294, where the directors act in good faith for a purpose ostensibly within their powers, the court may intervene in exceptional circumstances. And indeed there are cases very much akin to Wednesbury, and we've Equitable Life, the celebrated Equitable Life case is one of them that's in the bundles, and there's a very interesting decision of His Honour Judge Pearl, right at the very end of Bundle 2, a case called Sunrise Radio, in which he analyses the situation in relation to Wednesbury. And so...
Whereabouts in that very lengthy decision?
I'm sorry about that. It picks up at... It really picks up on page 29 of the judgment, my lord. What he is doing is he is analysing in the context of a minority shareholders petition by Miss Coley an issue about the first issue of alleged unfairly prejudicial conduct, which related to a rights issue, and he deals with authorities on this from about 28. A little bit earlier, in fact, but he refers to Howard Smith and Ampol at 82, and then he comes on to a case called Ex parte Glossop at 86, which is a well-known case as to shareholders being adversely prejudiced, unfairly prejudiced, if distributable profits are in fact not distributed to them and are just sat upon. And Mr. Justice Harman in that case analyses it over onto page 30 in conjunction with Wednesbury. And then his lordship goes on over the next 2 pages, dealing with other cases where it might be said that that cases dealing more with constitutional matters concerning the company. For example, at paragraph 93, there is a case referred to about setting aside shares for forfeiture, or forfeiting shares for non-payment of a call on the shares, which is, as it were, a constitutional matter. But what's being talked of in the Smith and Fawcett matter is really matters of true commerciality and management. And of course the courts will be very loath to interfere. I suppose you might get into a Wednesbury type example of a company purportedly refusing to deal with somebody because they have red hair, which is indeed comes from the celebrated passage in Wednesbury, but that would hardly be a decision, it would just be almost a nullity. So what Mr. Justice Lewison is saying there is that bona fides can't give vires. You can't think just because you think something's all right doesn't mean to say it is, or just because you think you've got authority or you think something's intra vires, it doesn't mean to say it is. And lastly, I take on board what my Lord Phillips was saying about the reality of valuation. And could I just tell your lordships that at trial, the expert evidence both the experts, property experts, Mr. Farr from a learned friend and a Mr. Preston for me, produced reports in relation to the value of the asset which was sold, namely YMS1 having the whole YMS portfolio. So they valued the properties, and they valued the properties as is with the benefit of the tenants and so on. Mr. Farr's valuation was about £5.5 million, and Mr. Preston's was, I think, over 12. And the learned judge didn't just assumed, for argument, an undervalue, but he did say at paragraph 106 of the judgment, on page 37 of tab 5 in the core bundle, that so far as valuing the tenants' covenants were concerned, Mr. Farr did sit at an extreme end of pessimism, in that I think he attributed a value of virtually nothing to the tenants' covenants. And we do now know, although this is after acquired facts after the trial, that in fact the properties were disposed of for in total about 16.5 million. So there's a lot of material there as to a substantial undervalue, we would say. Absent the point, which was amongst the protagonist minds at the time, which was something of a construct.
Has the full repair in covenants been proved relevant in history?
Well, in fact, I think they've done rather better than that, for the simple reason that most of the disposals took place without tenants. So they were on the basis of freehold, empty properties. So in fact, the disposals do go to show quite a large inherent value in this property portfolio. Mr. Farr reached the position with his valuation of £5.5 million that when you take liabilities into account, the whole company actually had negative value. It wasn't even worth £63,000. So that was the source of careful scrutiny before the trial judge, but not something he ruled upon. So, my lords, those were my two last points, I think, unless I can assist any more at this stage.
No, thank you very much.
I'm much obliged.
Yes, Mr. Nick.
My lords, it's common ground in this case that the transaction in question, that is the sale of the YMS shares by PPC to Moorgarth, was believed to be at market value, and it was intended to be at market value. That was a belief and intention shared by the directors and shareholders of PPC, of YMS, of Moorgarth, of TUK, by all the TUK Trader, by all the companies that we're concerned with here. It was a transaction that was unanimously approved by the shareholders of PPC at the time. The allegation, which the trial judge has not resolved, is that Mr. Moore, albeit acting wholly honestly, and albeit believing that the transaction was for full market value, acted negligently, and that, in fact, it was at less than market value. And both of those matters, that is the question of whether or not it was at market value, and the question of whether Mr. Moore was negligent, that is in breach of his duty of care as director, are matters that are still unresolved, although the judge did hear evidence on those facts. What my learned friend seeks to say is that a transaction that was intended to be an ordinary sale transaction at market value is ultra vires, that is void and of no effect at all, merely because it was in fact at undervalue, and the director of PPC was negligent in making sure that it was at proper value. That, as has been noted this morning, could give rise to some unusual and capricious consequences. It would seem, as we see it on this side, to depend on the mere accident of whether someone happened to be a shareholder, whether the purchaser happened to be a shareholder. And one can think of examples. My learned friend mentioned in passing an example of the Asda supermarket selling some of its goods at less than their true market value, should it depend on whether the customer happens to have some shares in Asda as to whether that transaction is void and of no effect? I'll come to section 263 in due course, but concentrating on the position at common law for the moment, if that is right, there is no saving for the recipient of the property. There isn't the 277 protection at common law. If it's void and of no effect, then the property must be delivered back up to the company. And we say that that would be an odd and unusual consequence. Of course, it is right that it's important that the principle that companies cannot distribute profits, cannot declare dividends and make payments to shareholders except where there are distributable profits to do so, is a principle that needs to be maintained and it needs to be enforced. But the question, the wide question for your lordships, is whether it is sufficient that it is enforced by a claim against the director for breach of duty, at least where that transaction has been unanimously approved by the shareholders, or whether it should give rise to the consequence that the transaction is wholly void. On our case, there are circumstances in which the transaction is wholly void, but it's wholly void only if the purpose of the transaction, that is, the motives of the company and of its shareholders, was in fact to give a benefit to the shareholders, was to make a distribution to the shareholders. If what was intended was to enter into a commercial transaction for full value, then we say it does not fall within the principles within Reholt, Aveling Barford, Macpherson and the other cases. And I'll set that out in a little bit more detail in due course. Lords, before I do that, could I turn to 2 or 3 paragraphs in the judgment of Mr. Donaldson at first instance, and then to 1 or 2 of the underlying documents. And this will only take a couple of moments. So I'm in the appendix, starting at page 17, which is a couple of pages into Mr. Donaldson's judgment. And at paragraph 14, he deals with the SPA. He says the SPA provides in clause 4.1 that between the date of the agreement completion, the vendor shall procure the transfer by the company of the entire issued share capital of YMS1 to Fold-Free, pursuant to an agreement in agreed form. As originally drafted by Mr. Paul Emmett of Walker Morris, the agreed form defined the purchase price as the sum of blank to be the net asset value of the company, and then net asset value was changed to market value at the instance of Mr. Gerber of DLA, and the SPA was signed on the basis of that formulation. And then paragraph 15 deals a point which I think Lord Mance raised this morning. What would have happened if the price hadn't been 63,000 but had been a different price? And the short answer is it would have made absolutely no difference at all to the overall transaction. And Mr. Donaldson explains why here.
Can you just explain, though, why Mr. Donaldson is right in what he says in paragraph 15?
He's writing that, I think, in reaction to the forensic point that I was making.
Slightly, yeah, sorry.
I was simply making a forensic point that this was an attempt by PPC and Mr. Price through PPC to get a windfall benefit. But had it been the case that the price paid for the sale of the YMS shares was 4 million more, then the price paid for Tradegrow's shares in PPC would have been 4 million more. Because Wigmore Street Investment was paying for the Tradegrow shares based on the net asset value of PPC.
Well, I'm sorry, I interrupted you.
What I was going to do was simply add one more
No,
sentence.
well, do finish before I ask you a question.
Yeah. PPC's share value, the net assets value of PPC would have increased by 4 million had, prior to completion, it sold the YMS shares not for £63,000 but for £4,063,000. So that's why it would in fact have made no difference at the end of the day to what Wigmore Street Investments was obtaining.
I can see that, and my lord's got a question.
Well, I have read and puzzled over this paragraph 15 many, many times, and I see two difficulties about that. One is that it assumes that Tradegro was selling 100% of PPC and not 75%. It may be that Mr. Price's 24.9% had been issued on special terms, such as they were valueless, but if so, the judge absolutely does not explain that.
No.
That's one difficulty.
Yes.
And the other one is that we know that the SPA was signed on the 3rd of October when the details of the subsale had not been sold.
Yes.
And the SPA said the initial consideration for these shares was £384,000.
Yes.
There it was in black and white.
Yes.
It didn't depend on any formula. So I don't see how you can assert that it all would have come out in the wash as a result of adjustment.
Lord, can I try and answer? But there
please,
is, in my submission,
yes.
a good answer to both of those points. And the answer to, if I could deal with the second point first, the answer to the second point is that though there was the initial consideration put in the SPA, there was then a further provision for there to be a reconciliation.
I'm sorry, I know there was, but that was 10% of the growth between completion and 3 years after completion.
Yes, yes.
But if the initial price was right at completion, which was going to be calculated on a quite different basis,
yes.
that wasn't going to affect the result of that SPA.
No, the answer is that they would have reached a different price for the sale to Wigmore Street Investments. It was quite clear that in calculating the price at which Wigmore Street Investment was to purchase the Tradegro shares, they were taking into account the value that they were going to get for the YMS shares on the sale to Moorgarth. So that, as a matter of fact, there would have been that adjustment, and that was quite clear on the evidence. And my recollection is Mr. Price accepted that in cross-examination. I mean, it's a matter of what the agreements say. As to the first of Your Lordship's point, there's only 75%, not 100%. The way I'm afraid I don't have at my fingertips, but the way the agreement worked is he would pay 100% of the uplift in value, not simply 75% of the uplift in value.
Who's he?
He is Mr. Price,
Yes.
Through Wigmore Street Investments, his company. Lord, I know it appears a little puzzling because Mr. Donaldson didn't set it out, but it's clear if one looks at the agreements in detail, and I'm sorry, I don't have it absolutely at my fingertips that was so. It wasn't a matter of dispute between the parties. It's a submission that we made then, which was accepted, say my recollection is, by Mr. Price in cross-examination. It's a submission that we made in the Court of Appeal as well. And there's never been any debate about that fact. It's only a forensic point because I accept that this is a claim by PPC, and the question is whether PPC has that claim, not whether looking at PPC and its shareholder Wigmore Street Investments together, they would be better off or worse off in particular circumstances. So I'm not saying it has any consequence, but I was simply seeking to deal with the point that I think my Lord Mance mentioned this morning.
I mean, we're stuck with the agreed statement of facts, but
Yes.
I do find paragraph 15 very puzzling indeed.
Well, Lord, if it would assist, I'm sure we could look at the agreements in a bit more detail and try and get chapter and
we
verse
can't
on.
start going into the facts which aren't before us, aren't before this court.
No.
What puzzles me about paragraph 15 is also that it doesn't seem to say what you say orally, and in your paragraph 9 it says, it may not matter, but I mean, I would understand it as consistent with what you said if it read, this was because the payment for those shares was to be affected by a reduction in the indebtedness of PPC to the TUK group. If it had then said, and hence a corresponding increase in the amount payable by WSIL, which is what you just said. You said the amount payable, and you say in your case that REPC, WSIL, would have to have paid more pursuant to the SPA. And here, Mr. Johnson seems to say that there will be a reduction, i.e. a double whammy, a double gain by Mr. Price's side. So he may have got it wrong, it seems to me, Mr. Johnson. On his view, WMIL, or Price's side, gets both the extra 4 million and a corresponding reduction in the amount payable, which is a double gain.
Yes.
Instead of a cancelling out.
Lord, that clearly wasn't the intention. Sorry, rather than try and waste time over, trying to explain
I understand.
The basic point is not a matter of dispute, that the money would have gone round.
I've got your point.
Speaking for myself, I'd find it helpful to have a short note on this.
Well, Lord, I can certainly do that if your Lordships would find that helpful, and I think it will be simply a question of identifying the relevant provisions in, I think, the 3rd of October SPA. I'm certainly not envisaging it involves looking at any other facts. I hope I'm right in saying that's the position.
But it had better be an agreed note if you can, because otherwise we're just going to get deeper into the mire, I think.
Not of course, and we're all, I think, anxious that doesn't happen. Carrying on in Mr. Donaldson's judgment at paragraph 16, he says at the end of 15 that the figure was unimportant, but it did feature strongly in the negotiations for two reasons. And 16, first was a desire on the part of the lawyers to avoid any later suggestion that the disposal of YMS1 was being done on terms which constituted financial assistance or infringed section 151. And then he goes on to deal in some detail with what was said about that. And the second consideration was a consideration that it shouldn't be too high so as to increase tax. And the only other passages I wanted to show your Lordships in Mr. Donaldson's judgment are at page 24 and 25 of the appendix. That's paragraph 41 and 46. At paragraph 41, Mr. Donaldson says, in the present case, counsel for PPC expressly accepted that Mr. Moore subjectively knew and intended the YMS transaction to be a sale at market value. And indeed, the contrary was never pleaded or suggested by him to Mr. Moore in cross-examination. And then at paragraph 46, in the present case, there was no evidence of any such intentional conduct by Mr. Moore, that is to prefer Moorgarth over PPC. Indeed, the contrary was never suggested by PPC, let alone explored by PPC in cross-examination of Mr. Moore, and it was, as I recorded above, accepted by PPC that Mr. Moore subjectively knew and intended that the sale was at market value. Well, that's all I wanted to show you, Lordships, in that judgment. Could I show you two documents that you haven't yet seen today? The first is the SPA itself, and could I take your Lordship simply to the relevant provision in it, which is at page 53 in the appendix, and it's clause 4.1. And this is the relevant provision that between the date of this agreement and completion, the vendor shall procure the transfer by the company of the entire share capital of YMS1 to Foldfree, pursuant to the agreement in the agreed form. And that agreement we have starting at page 40 of the bundle. And the only thing to note about it, it's a very short agreement that goes on to page 45, is that it is an agreement for the sale of shares in entirely conventional and simple form. So this was a transaction intended to be a sale at market value, which purported to be a sale at market value, which was believed by everyone to be a sale at market value. That's all we get from that.
Is the other point to note that the agreement in agreed form wasn't in fact agreed on the 3rd of October. It wasn't agreed until about probably the 20th.
No, that's right.
So, I mean, in reality, it's doubtful whether there was any enforceable agreement at all until the 20th of October.
Lord, I think that may be right, yes.
Yeah.
That may be right. But the parties clearly, the reason to take your lordship to the 3rd of October agreement, apart from to set the scene, was that was what the parties intended to achieve. May not have been legally enforceable, but they intended to achieve a sale of the shares, and there were intensive discussions between them, and your lordship seen the details of that from Mr. Donaldson's judgment, about how market value was to be calculated, because they were very concerned to achieve market value. Lords, the next thing I think I need to do is to set out the principles which, in my submission, emerge from the various relevant cases, in particular Ridge, Reholt, Rolled Steel, Aveling Barford and Macpherson. And Lords, to help my submissions on that, what I have done is distilled them to 7 propositions. I've got those typed out, and to save your lordship's note, could I hand those up? Give me one to give to you. And what I was proposing to do was take your lordship through those propositions, then to go at quite a canter through the authorities, because of course my learned friends already set the scene. I simply want to highlight 1 or 2 relevant passages, in the hope of demonstrating that these propositions are made out by those authorities. And Lords, at this stage, I'm still concentrating on the common law position, and I'll come to section 263 in due course. But to show your lordships where I'm going, in my submission, section 263 certainly imposes no higher liability than the position at common law, and in one interpretation, and we'll need to look at Macpherson for this, is of more limited effect. This is on the question of whether something is a distribution. So, Lord, these are the 7 propositions. Firstly, that a company cannot ratify a transaction effected by its directors in breach of their fiduciary duties if it amounts to a fraud on the company's creditors. Learned friend has helpfully made the distinction this morning between ultra vires in its true sense of being outside the capacity of the company, that is, outside its memorandum of association, and something which is within the capacity of the company but outside the authority of the directors. That still doesn't bind the company unless the company ratifies it. And what this first proposition says is that there are limits on the power of a company to ratify a transaction, and that limit is if the transaction amounts to a fraud on the company's creditors. I'll take your lordships to, in particular, Rolled Steel in relation to that. Secondly, the transaction is a fraud on the company's creditors if the purpose of the transaction is to make an unauthorised return of capital to shareholders. The key here in my submission is to look at purpose, and that's something that goes through all authorities. Thirdly, that the purpose of a transaction may be to make an unauthorised return of capital to shareholders in one of 2 sorts of situations. Either where it purports to be, in fact, a return of capital to shareholders, or where its purpose is, in fact, to return capital, but it pretends to have a different purpose. So if one pretends something is interest, as in Ridge, or if one pretends it is remuneration, as in Reholt, or pretends it's some other commercial transaction, but actually the purpose of the transaction is to return capital, then it's not the question of saying that the transaction is a sham. The transaction is what it is, but it has the purpose of effecting a return of capital to shareholders. And that's what strikes it down. And that's what we see in the authority.
How do you reconcile that with the dicta about the lunatic?
About the lunatic?
Yeah.
Lord, I reconcile the dicta about the lunatic. This is Lord Justice Bowen's dictum about that, on the basis that that is about the question of good faith or honesty. That if you've got someone going around who simply thinks he is entitled to give away all the company's money, then he may be thinking he's not doing anything wrong, but his purpose is in fact to distribute the company's money. And if he gives it to the shareholders, that is the true purpose. Can I just go to that dictum of Lord Justice Bowen, which I think it's referred to. It's in Re Holt. So this is tab 16 in the first bundle of authorities at page 1027. Now, I'm conscious I need to go through my whole set of propositions, but can I deal with that point straight away? It's page 1027, between B and D. And Malone and Friend started reading at the sentence starting, bona fides cannot be the sole test. In my submission, one needs to start a little earlier up, starting from the beginning of it. It says, now can a majority compel a dissenting unit in the company to give way and to submit to these payments? We must go back to the root of things. The money which is going to be spent is not the money of the majority, that's clear. It's the money of the company and the majority want to spend it. What would be the natural limit of their power to spend it? They can only spend money which is not theirs but the company's if they are spending it for the purposes which are reasonably incidental to the carrying on of the business of the company. That's the general doctrine. So that's the test. Bona fides cannot be the sole test. In other words, the fact you think what you're doing is okay doesn't get you off the hook. Otherwise, you might have a lunatic conducting the affairs of the company and paying away its money with both hands in a manner perfectly bona fide, yet perfectly irrational. The lunatic is simply giving away the company's money. He's not doing so for the purpose for a purpose which is reasonably incidental to the carrying on of the business of the company. So that's how I seek to explain that particular dictum of Lord Justice Bowen. Well, can I return to my propositions? I dealt with the third one. The fourth is that in considering whether a transaction which purports to have a different purpose is in fact a dressed-up return of capital to shareholders, what matters are the motives of the directors in effecting the transaction, not whether the transaction is for the benefit of the company. That is, not whether or not the transactions are undervalued, but what the motives of the directors are. And we see that very clearly from Re Holt. 5, and this is where the confusion may arise. Evidence that, had the directors exercised due care, they could not reasonably have believed that the transaction was for proper value or in the interest of the company, may be evidence that the directors did not in fact believe that the transaction was for proper value or in the interest of the company, and that the purpose of the transaction was in fact to return capital to shareholders. So if one has no actual evidence of motive, then one can look at the question of whether this was a commercially sensible transaction entered into with care. If not, that might provide evidence about the motive. Here, of course, we do have direct evidence of motive. So we don't need to look at the question of whether it was undervalued or whether it was negligent. 6, if the directors acted with the intention of defrauding the creditors or knowing that what they were doing was wrong, then the court will readily conclude that they entered into the transaction with the purpose of returning capital to shareholders. And 7, and this is the Lord Justice Bowen point, however, the fact that the directors acted in good faith in the sense that they believed that they were entitled to enter into the transaction and were not acting improperly does not preclude a finding that their purpose was in fact to return capital to shareholders. In that sense, it's an objective test. It's objective in the sense that you don't need to believe that what you were doing was wrong. The court will examine what your true purpose was in fact. If there's direct evidence of one's intention and motive, then it's straightforward. As we say, it's straightforward here. If there is not that direct evidence of intention, then it can become quite a difficult process, as it was in Re Holt. So, Lord, those are the propositions that we commend to your lordships. Can I go through?
Purpose is what? Is that a subjective
purpose,
state of mind, or is it a state of mind at all?
I don't seek to make any distinction here between purpose, intention, and motive. And your lordship sees all three words.
So they're all the
used.
same, are they?
They're all the same so far as I can see here. But one needs to be clear, if one talks in terms of intention, what that intention is in order for it to be a fraud on the creditors, there needs to be an intention to return capital to shareholders.
When you talk about the purpose of a transaction, and if it's a transaction between two parties,
Yes.
is that the intention of both parties?
No, the purpose here, in my submission, means the purpose of the company in question, which is seeking to say that the resolution of the shareholders is not binding on it. It's that purpose. Because at the root of this is the idea that although ordinarily the shareholders in general meeting can do anything they like, so far as ratifying an intra vires breach of duty is concerned, there is a limit on the power of the shareholders. And what the shareholders cannot do is ratify a transaction which is intended to be a distribution of capital to them in circumstances where there are not distributable profits. So therefore,
But could I just question that last reply you gave to Lord Clerk? I mean, just getting a bit more specific on the facts of this
Yes.
case. If you are talking about an admitted sale at an undervalue,
yes,
and the question is, looking at your principles here, whether that is indeed a sale, should be treated as a sale, or whether it should be treated as a distribution dressed up as a sale.
yeah.
Surely the state of mind of both parties to a sale at an undervalue is going to be material, isn't it? As objectively established by the evidence. It may be that the seller is more important than the buyer, but you're not saying the buyer's entirely unimportant, are you?
I'm not sure it matters on the facts of this particular case, because everyone intended it to be a sale at market value. I think that's the first thing I'd say as to that. It's clear that Moorgarth shared the same state of belief as YMS, as PPC.
But I understood your answer to Lord Clerk to be that it didn't matter what Moorgarth thought.
In my submission, that is right. I don't resile from that point, because, really for the reasons that I gave to my Lord Clerk, that we're looking at the question of purpose here to decide whether or not the shareholders of PPC here are competent, whether they are competent to ratify a transaction. And what matters is, and the principle at stake here is that where the shareholders are ratifying something intended by its directors to give a distribution to those shareholders, then it's incompetent. And so the concentration is very much on the purpose and intention from the point of view of the directors of the company. And the starting point here is that there is to come within this principle, is that there is a breach of fiduciary duty by the directors of the company, of PPC. It would have to be on the facts of this particular case.
Well, surely the starting point is whether this is a distribution out of the company's assets which falls foul of the rule. And that depends in this case on how do you characterize, it's a word I think both sides have used, how do you characterize this transaction? I do find it a bit odd if you say that in order to decide how to characterize the transaction, you look only at the way it was viewed from one side and not at the way it was viewed from both sides.
Look, it may be that's right.
Anyway, that's what you say about it.
You'd surely have to reformulate propositions 2 and 3 if you were focusing only on the purpose of the directors. If you talk about the purpose of a contract, you're focusing on the the whole transaction.
Yes.
And that's
I'm
the
thinking,
statement about it.
I'm sorry,
Sorry.
but I'm trying to remember exactly how Lord Wilberforce put it in one of his famous judgments about taking the surrounding circumstances
Yes.
into account.
Yes.
And he says, doesn't he, something like, looking at the essence of the transaction, what were the parties about?
Yes.
He doesn't say what was the vendor about, not
No.
leaving aside the purchaser.
Look, that might be right. We concentrate on the fact that that the concept of fraud on the creditors comes in at quite a late stage of the analysis. It's not that the starting point is to consider the purpose of the transaction. That comes in right at the end of the analysis. The first stage is to consider, is there a breach of fiduciary duties by the directors? If so, then, of course, the company can disown the transaction unless there has been the unanimous assent of the shareholders. If the shareholders have unanimously assented, are they competent in doing so? They're not competent in doing so if the breach of fiduciary duty in question involved a transaction that was intended by the directors to give rise to a distribution to the shareholders. So, my Lord, it's because we analyse it in that way that we say that the purpose is the purpose of the company, not the purpose of both parties of the transaction. If we're wrong on that, then I entirely accept that one needs to look at the purpose, taking into account the purpose of both parties. On the facts of this particular case, in my submission, it doesn't matter one jot, because everyone shared the same intention and purpose. But that's why I perhaps didn't readily agree with my Lord Clerk, because our analysis of it starts from looking at the breach of fiduciary duty. It's important to bear in mind that what we're talking about here is not a transaction that is ultra vires, but intra vires transactions. And this is made very clear in rolled steel. Intra vires transactions, which the shareholders are unable to ratify. And that, therefore, in my submission, gives rise to a different starting point. Lord,
It's not apparent to me why the fact that you are dealing with ratification should confine you or them to their own motives. Surely they have to form the same judgment that my Lord's referred to as to how this transaction should properly be categorised. And if looking at the interests of both parties, you conclude that it's a perfectly ordinary sale transaction,
yes,
then it can be ratified.
Yes.
There's no problem about it. Yes. Anyway, so I don't quite see why your reverse analysis, looking at it through the question whether there can be ratification, actually alters the problem.
Well, it alters the problem, if I'm right on this analysis, because what the fraud on the creditors exception says is that there are particular types of breach of fiduciary duty that cannot be ratified.
Right.
Most breaches of fiduciary duty can be ratified. If one acts in conflict of interest, or if one prefers a third party as opposed to the company, right, that can be ratified. But there's a particular type of breach of fiduciary duty that cannot be ratified, and that is where the directors intend to benefit not a third party, but intend to benefit the shareholders. And that's why we say it's important to look at the purpose of the directors. But as I say, the alternative analysis is to look at the purpose of both parties to the transaction. And as I say, on the facts of this case, I'm not sure it makes a difference. But we say one needs to concentrate on the fact that the question here is whether the director's breach of fiduciary duty can be ratified by the company. So the starting point is the breach of fiduciary duty, rather than the starting point being that this is a transaction which gives rise to a benefit to the shareholders. Ross, can I go to the cases, and I'll deal with them in chronological order. starting with Ridge. So this is in the second bundle of authorities at tab 22. Obviously, it was only since Rolled Steel that, and the disapproval of the test in Lee Berens that Malone and friends referred to this morning, that there has been the conceptual purity about ultra vires. And even then, there wasn't, I'm afraid, that conceptual purity in the Court of Appeal hearing the Macpherson case. In Ridge, Malone and friends already taken your lordship to the passage at 495. Could I go back to 493? This was, as my Lord Walker, I think, said this morning, essentially an asset stripping case. The plaintiff acquired companies and asset stripped them by entering into debentures with them and then charging them extortionate rates of interest out of all proportion to the loan's advance. And one can see that from 493, about half a dozen lines down. It'll be further remembered that each debenture provide for payment of interest grotesquely out of proportion to the principal amount secured. The effect of this provision in every case, except that of Ridge Investments, being that the company concerned bound itself to pay within a few days after the advance a net sum by way of interest far greater than the amount of the advance. The Special Commissioners held that these payments were not payments of interest, and in my judgment they were right in this view. And then picking it up again at the new paragraph towards the bottom of the page, the rate of interest may be low or high, but it seems to me impossible to treat as having the quality of interest a sum greater than the principal advanced and payable a few days after the advance. The net interest on the Ridge debenture, namely £88,000, is less than the amount of the advance, that is 123, and the interval between the issue of the debenture and the payment of interest extended over 2 months. Here too, however, the ratio of interest to principal is such that it seems to me impossible to attribute to the payment the character of interest. So the short point is that Mr. Justice Pennycook was saying, although they said it was interest, they can't possibly have intended it to be interest here, because it was simply out of all proportion to the amount of the principal. And that's why at 495, he then concluded, and this is the new paragraph at 495, about half a dozen lines down, indeed the terms of each debenture indicate that on the face of it the so-called interest represented in fact a gratuitous disposition of an enormous sum by the company concerned in favour of Ridge. And he says, half a dozen lines further down, they cannot take assets out of the company by way of voluntary disposition, howsoever described. If they attempt to do so, the disposition is ultra vires. So, Lord, that's Ridge. It purported to be interest, but the purpose of the transaction was clearly to distribute sums to the shareholders. Lord, secondly, Reholt, and this is in the first bundle of authorities, at tab 16.
That doesn't come within any of your actual propositions. It's a variant on 4, I suppose, is it?
Yes.
Objectively, the transaction, although it's said to be interest, plainly isn't.
It plainly isn't interest. It was a dressed-up distribution. It was dressed up as interest, Lord. And
you don't actually have to form any view about anybody's intention. You just look at the transaction and you say, well, this is called interest, but it isn't interest.
Yeah.
Yes, but Lord, the reason one says it isn't interest is it can't have been intended to be interest. It was dressed up as interest.
Well, you can put it like that if you like, but I mean, that wasn't quite the way that Mr. Justice Pennycook put it. He just said, look at what happened. It's not interest.
Lord, it's not just me saying that. Mr. Justice Oliver
Well, I was just like relying on what Mr. Justice Pennycook put it.
Yes. Lord, in Ridge, there are 3 points I'd like to take Lordships to. Sorry, in Reholt. And the first is Mr. Justice Oliver's interpretation of the judgment in Ridge. And he refers to Ridge in 3 separate places. The first is at 1032, between G and H and 1032. Furthermore, I do not think that Mr Justice Pennycook himself envisaged his observation in the Charterbridge case as affecting the application of the Lee Behrens test to gratuitous dispositions by the directors of company assets, certainly so far as made under implied powers. In Ridge, he applied the principle to the purported exercise by directors of a power to issue debentures carrying an obviously sham rate of so-called interest. There does not appear to have been any evidence either as to the funds from which this came or as to the powers, whether express or implied, which the directors had purported to exercise. I think that the real ground for the decision was simply that no one had thought to justify the application either as being made under an express power or, if made under some implied power, as having any connection at all with anything that the companies were incorporated to do, and that it may indeed have been an illegal return of capital to the shareholders. And then, over at the next page, Mr Justice Oliver says, Mr Justice Pennycook commented on his decision, on this decision in the Ridge case, in the Charterbridge case, and his observations of this make it, I think, clear that his view of the applicability of the test to the situation with which he was confronted in the Ridge case, namely that of a gratuitous disposition by directors under implied power, remained unchanged. And so Mr Justice Pennycook, commenting on his earliest decision, is saying the relevant transaction in the Ridge case was a dressed-up gift of a large sum by certain companies to another company which had acquired their shares, clearly ultra vires. And then finally, at 1037, just above letter F, Mr Justice Oliver comes back to
What about D on page 1033? Perhaps that's a part of a longer passage which got to be looked at. Sorry, I interrupted you.
Yes, Lord, I think it's a very long, detailed judgment, this, of course, which refers in detail to the arguments of both counsel. 1037, I'm going to come back to some other passages in Reholt in a moment. I just wanted to pick up the references to Ridge. Letter F, just above F, Counsel for Liquidator submits that even given a bona fide unanimous resolution general meeting, it still must be a resolution to do something the company can lawfully do. It cannot, for instance, lawfully return money to its shareholders out of capital. That's plainly right, and Ridge Securities illustrates the proposition. That was a case of what Mr Justice Pennycook in the Charterbridge case described as a dressed-up gift of a company's funds to a parent company. And what dressed up means in these circumstances is a transaction, not a sham transaction necessarily, but a transaction that purports to have one purpose, but is in fact intended for a different purpose. That's what the concept means in my submission.
I don't want to start criticising your points, but really you've used purports in your paragraph 3 and purports in paragraph 4 in quite different senses. It would be a bit clearer, wouldn't it, if in 3 you said either where it overtly returns capital to...
Not I entirely accept that.
So, something like that. Otherwise it's a bit of a muddle, isn't it?
I accept that that's is a poor use of language. If it said overtly in 3, that would be much better. Otherwise, it could indeed create confusion.
How do we read Ridge and Halt in the light of rolled steel? There's a lot of talk about ultra vires in the wrong sense in those cases, isn't there?
Yes, and of course rolled steel is quite helpful. Well, Reholt is already putting some doubts as to the question of whether of the different senses of ultra vires. Yeah. Rolled steel is nailing the point. What I think it means in light of rolled steel, that when we look at the references in Ridge and Reholt to ultra vires, one needs to be cautious about whether ultra vires is being used in the narrow sense, the strict proper sense, or in a different sense. And in my submission, it's clear that in Reholt and in Ridge, it's not ultra vires in the sense of being outside the memorandum. The memorandum of association of the company did include a power to enter into debentures which contained provisions for payment of interest. There was a provision in the memorandum in Reholt to allow remuneration to be paid to directors. And rolled steel makes it quite clear that if there is a transaction which is capable of being within the memorandum, if it's affected in the interest of the company, then if it's affected not in the interest of the company, it's still intra vires, but it's an abuse of power. So in my submission, the cases are right, they're rightly decided, but one needs to be a little cautious about the language that's used.
Just testing that on 1044 in Holt.
Yes.
How would you reformulate the sentence at the end of the first full paragraph?
Thus, if, for instance, if a dividend is paid in part out of capital and part of it out of profits, well,
What would you? How?
it is a breach of fiduciary duty by the directors. Two other things I wanted to show your lordships in Reholt. The first was the nature of the claim in Reholt and the nature of the defence. Page 1023 at letter B makes it clear that this is a claim, as I think my Lord Collins pointed out this morning, is a claim for misfeasance and breach of trust. So it has to be shown that in making these payments, the directors were in breach of some fiduciary duty. The claim was for breach of fiduciary duty. The defence was that it was approved by the company, and one sees that at 1024E and onwards. Counsel for the liquidator concedes that he has to the payments of remuneration were formally determined by the company at general meetings. He later goes on to say that some of them were dealt with informally, but as it was a two-man company, because of the principle in re geomatic, that was just as effective as a general meeting resolution. So that was the claim and that was the defence to it. But the fact that it was resolved in general meeting, it didn't work. Moving to the substance of what Mr. Justice Oliver said in Reholt, three other short passages can I invite your lordships to look at. The first is at 1038, starting at letter C. And these relating to the question of whether, if it's an undervalue, that makes it a fraud on the creditors, that makes it ultra vires in a wide and accurate sense. And at C, he says, I accept entirely the submission of counsel for the liquidator that a gratuitous payment out of the company's capital to a member, qua member, is unlawful and cannot stand, even if authorised by all the shareholders. What I find difficult in accepting is that assuming a sum to be genuinely paid to a director shareholder as remuneration under an express power, it becomes an illegal return of capital to him qua member if it does not satisfy some further test of being paid for the benefit of the company as a corporate entity. If he genuinely receives the money as reward for his directorship, the question of whether the company is beneficial to the payment is beneficial to the company or not cannot, as I see it, alter the capacity in which he receives it. So undervalue is not what matters. What matters is what the transaction is intended to be. Then at 1039, the same sort of point is made at rather greater length in a passage that I think learned friend took your lordships to. So this is starting at B. He says, what I think 1039B, what I think counsel submissions comes to is this, that while the company has divisible profits, remuneration may be paid on any scale which the shareholders are prepared to sanction within the limits of available profits. But as soon as they cease to be divisible profits, it can only lawfully be paid on a scale which the court, applying some objective standard of benefit to the company, considers to be reasonable. So that's the submission that is made, but that's rejected. But assuming that the sum is bona fide voted to be paid as remuneration, it seems to me that the amount, whether it be mean or generous, must be a matter of management for the company to determine in accordance with the Constitution, which expressly authorised payment for director services. Shareholders are required to be honest, but as counsel for the respondent suggests, there's no requirement they must be wise. It's not for the court to manage the company. And then there's I think yet another reference I failed to pick up at 1039E to ridge and dressed up gifts. And then at the paragraph starting between E and F, well, I think I need to start a little higher in order to make sense. Perhaps I need to read the whole of D and E. Counsel for the liquidator submits, however, that if this is right, it leads to the bizarre result that the meeting of stupid or deranged but perfectly honest shareholders can, like Lord Justice Barron's lunatic director, vote to themselves qua directors some perfectly outlandish sum by way of remuneration, and that in a subsequent winding up, the liquidator can do nothing to recover it. It seems to me that the answer to this lies in the objective test which the court necessarily applies. It assumes human beings to be rational and to apply ordinary standards. In the postulated circumstances of a wholly unreasonable payment, that might no doubt be prima facie evidence of fraud. Not fraud, evidence of fraud, but it also might be evidence that what purports to be remuneration was not remuneration at all, but a dressed-up gift to a shareholder out of capital. So it's only evidence. And this, it seems to me, is the real question. This is whether it was remuneration or a dressed-up gift to shareholders.
Well, that's
out of
surely an
capital.
objective question.
Well,
It's got nothing to do with anybody's state of mind. You look at it and see whether it is or isn't.
Lord,
You just say it isn't remuneration.
Lord, in my submission with respect, that's not what Mr. Justice Oliver is saying.
Well,
And that becomes clear as one goes on.
it all depends what you mean by dressed up.
Well, yes, but I think he makes that clear as one goes on, because he says, I do not think that in circumstances such as those in the instant case, the authorities compel the application to the express power of test of a benefit to the company, which certainly construed, as Mr. Justice Plowman held that it should be construed, would be largely meaningless. The real test must, I think, be whether the transaction in question was a genuine exercise of the power. The motive is more important than the label. Those who deal with to something to that, and then about 3 lines down, they have to accept the shareholder's assessment of the scale of that remuneration, but they are entitled to assume that whether liberal or illiberal, what is paid is genuinely remuneration, and that the power is not used as a cloak for making payments out of capital to the shareholders. So the question is, what is the motive in making the payment? What is the purpose of the payment? But the question is not whether it was an undervalue, whether the directors didn't exercise sufficient care. But if it was an undervalue and they didn't exercise sufficient care, that may be evidence of their true motive. And Lord, one final passage in Re Holt, if I may, at 1044. This is 1044, just above F, 5 lines from the bottom of the paragraph ending after F. Remuneration does not cease to be remuneration because it is generous, or even perhaps unwisely generous. But there's an obvious difficulty about fixing any point at which it can be said that a purported exercise of the power to pay ceases to be genuine. In the absence of any evidence of actual motive, the court must, I think, look at the matter objectively and apply the standard of reasonableness. But that's in the absence of evidence of actual motive. Of course, in the absence of that evidence, and even to judge the veracity of that evidence, it's relevant to look at whether this is a commercially sensible transaction, whether the directors acted properly. Only in those circumstances.
Doesn't the next paragraph slightly affect it? Some evidence was standard in the interview, some of £10 a week, some which was thought justifiable to pay in May 78 for Mrs. Charles was present, and some, in fact, the sum paid from then on. I don't think a court can proceed on a minute examination of whether that did or did not conform to the average sum paid by companies of this size to non-working directors. It was the sum which the company was professionally advised could legitimately be regarded as remuneration. I find it difficult, therefore, to say it was not genuinely paid as such, or that to vote it was beyond the power, excepting, however, there was no intention to defraud anyone. I cannot regard the payments made to Mrs. Charles as in excess of this weekly amount, however well-intentioned, as being anything more than disguised gifts out of capital. How's that consistent? However well-intentioned suggests you're not looking at motive.
Lord, my submission, however well-intentioned, goes to the question of good faith, in the sense of, did the directors believe they were doing anything wrong? They didn't believe they were doing anything wrong, and well-intentioned refers to the fact that Mrs. Charlesworth, if I recall, was ill, and it wasn't her fault that she couldn't perform her services to the company, and they wanted to make sure that she was financially okay. That's what well-intentioned means in those circumstances. It goes back to a passage earlier in the judgment, which I think my learned friend cited, about compassion having no place in the bar of the court, or words to that effect. This wasn't a case where there was any direct evidence about whether they intended it to be as remuneration or intended it to be a return of capital to the shareholders. So it wasn't an easy case, and why Mr. Justice Oliver had to have regard to the sort of sum that one could legitimately regard as remuneration. But he was quite clear that the question was not what would be the right sum for remuneration, and any sum beyond that must be regarded as a payment of capital. And he says that in all the three passages that I took your lordships to a moment ago. But in my submission, that is perfectly consistent with what is being said. One's looking to see what was the purpose here, and there was no direct evidence of purpose or motive at all. And his analysis of, he said that it was the same rationale as the Ridge case, which he said was a dressed-up gift. And that involved looking at motive, intention, or purpose, without getting into the debate about precisely what that means. So, my Lord, in my submission, I do find support for my propositions in Re Holt. Lord, can I turn now to rolled steel? That is in the other bundle of the second bundle of authorities, starting at tab 23, and it's a long, detailed judgment that the facts are really quite different, and I don't think we need to look at them. Can I take your lordship firstly to 277? Well, perhaps at the very bottom of 276. Lord Justice Slade is setting out what Mr. Justice Feinlott at first instance decided, and in the second last line says, after a careful review of the authorities relating to ultra vires, he expressed the opinion that even when the question in dispute relates to the capacity of a company to enter into a given transaction, the phrase ultra vires may be used A, in a narrow sense to describe a transaction which is outside the scope of the powers expressed in the memorandum of association of a company, or which can be implied by reasonably incidental to the furtherance of the objects hereby authorised, and B, in a wider sense, to describe a transaction which, though it falls within the scope of the powers, is entered into for the furtherance of some purpose which is not an authorised purpose. And as we'll see, Lord Justice Slade said it's only the narrow sense that is the proper sense that one should use. And then, after a very long examination of the authorities, at 295, Lord Justice Slade summarises the relevant principles in a list of number points starting between A and B. My conclusions from these authorities and these questions of principle may be summarised as follows. 1, the basic rule is that a company incorporated under the Companies Act only has the capacity to do those acts which fall within its objects as set out in its memorandum of association, or are reasonably incidental to the attainment or pursuit of those objects, and that depends on the true construction. 2, nevertheless, if a particular act is of a category which from the true construction of the company's memorandum is capable of being performed as reasonably incidental to the attainment of the or pursuit of its objects, it will not be rendered ultra vires the company merely because in particular instance its directors in performing the act are in truth doing so for purposes other than those set out in the memorandum. subject to any express restrictions on the relevant power which may be contained in the memorandum, the state of mind or knowledge of the persons managing the company's affairs or the persons dealing with it are irrelevant to considering questions of corporate capacity. 3, all due regard must be paid to any express conditions attached or limitations on the power to borrow. The court will not ordinarily construe a statement in the memorandum particular power is exercisable for the purposes of the company as a condition limiting the company's corporate capacity. It will regard it simply as imposing a limit on the authority of the directors. 4, at least in the default of the unanimous consent of all the shareholders, as to which see below, the directors will not have actual authority from the company to exercise an express or implied power other than for the purposes of the company as set out in the memorandum. And then 5 and 6 I don't think we need to look at. But then picking it up again at 296 at letter C, the judge explained that the reason why he regarded a transaction which is within the powers express or implied of the company, but which is entered into for a purpose which is not authorised by its memorandum of association as equated with one which is ultra vires in a narrow sense, is that such a transaction, like a transaction which is ultra vires in a narrow sense, is incapable of being made binding on the company even by the assent of all the members. We've had the benefit of extensive argument, if any, as to which the assent of all the members is capable of binding it to a transaction of this nature. Since the shareholders' consent point is not open to British Steel and Mr. Cooper, I'll only say a few words on it obiter. First, if an act is beyond the corporate capacity of a company, it's clear it cannot be ratified. As against the company itself, an ultra vires agreement cannot become intra vires by means of estoppel, lapse of time, ratification, acquiescence, or delay. However, the clear general principle is that any act that falls within the corporate capacity of a company will bind it if it's done with the unanimous consent of all the shareholders or is subsequently ratified by such consents. This last mentioned principle is certainly not an unqualified one. In particular, it will not enable the shareholders of a company to bind the company itself to a transaction which constitutes a fraud on the creditors, see Re Holt. But none of the authorities cited convinced me that transaction which falls within the letter of the express or implied powers of the company, does not involve a fraud on the creditors, is assented to by all the shareholders, will not bind the fully solvent company merely because the intention of the directors is to effect a purpose not authorised by the memorandum. And, Lord, finally, at 302, Lord Justice Slade comes back to the question of the true sense of ultra vires. This is at 302, letter H. In my judgment, much of the confusion that has crept into the law flows from the use of the phrase ultra vires in different senses and different contexts. The reconciliation of the authorities can only be achieved if one first defines the sense in which one's using the word ultra vires. Because the literal translation of the word is beyond the powers, there are many cases in which the words have been applied to transactions which, although within the capacity of the company, are carried out otherwise than through the correct exercise of the powers of the company by its officers. Indeed, that is the sense in which the judge seems to have used the words in this case. For reasons which appear in my judgment, the use of the phrase ultra vires should be restricted to those cases where the transactions beyond the capacity of the company and therefore wholly void. So, Lord Justice Slade, just going back to 296, is putting the doctrine principle, if that's the right word, that one gets from the Re Holt case, as full square within the fraud on the creditors exception to the general power of shareholders to ratify breach of fiduciary duty by directors. Lords, Aveling Barford, first bundle of authorities, tab 10, in my submission is entirely consistent with that. And is an illustration of that proposition. This was a case of an undervalued transaction with a shareholder that was known and intended to be at an undervalue. One can see the nature of the claim made at 630 letter E, that it was a claim for breach of fiduciary duty, right at the end of that paragraph. And one can again see the defence that was made to that, and this is at letter H, unanimous approval of the shareholders. So to that extent, the claim and the defence are entirely the same as Re Holt. And Mr. Justice Hoffman refers to the bottom of that page, general rules, any acts which fall within express or implied powers of the company conferred by the Memorandum of Association, whether or not a breach of duty on the part of the directors will be binding the company if it's approved or subsequently ratified. See rolled steel at 296. 296 is where the fraud on the creditors exception is referred to, but this rule is subject to exception, and he refers to return of capital. And continues between B and C, whether or not the transaction is a distribution to shareholders doesn't depend exclusively on what the parties chose to call it. The court looks at the substance rather than the outward appearance. Reference just above D to dressed up gifts of capital in the Ridge case, and then refers to Re-Holt, and at G described those as dressed up returns of capital. And then at H refers to the passage in Re-Holt that says whether the transaction was a genuine exercise is the question. The motive is more important than the label. And continues at the top of 632, this does not mean that the payments need to have been made fraudulently or in bad faith. Bona fides, in the sense of absence of fraudulent intention, and genuineness are not the same thing. So the fact that one believes what one is doing is okay doesn't mean that the transaction is in fact for a proper purpose. And then at letter C on 632, so it seems to me in this case that looking at the matter objectively, the sale to Perion was not a genuine exercise of the company's power, it was a sale at gross undervalue for the purpose of enabling a profit to be realised. It was a much dressed up distribution as in Ridge. And then at H, counsel for the defendant says that this was an act within the terms of the memorandum. It may have been a sale at undervalue, but it was certainly a sale. A conveyance in exchange for payment of money. It was not a sham. Terms of the transaction are no way different from those appearing in the face of the document. The purpose for which it was done was therefore irrelevant. That was the contention. Counsel submits the test for the genuineness of the transaction proposed by Mr. Just Oliver and Re-Holt admits by the back door all the questions about motives, state of mind and knowledge of the company's directors, which the Court of Appeal appeared to have expelled by the front door in rolled steel. Because of course, those questions are not relevant to the question of whether something is within the Memorandum of Association. But Mr. Justice Hoffman went on, it's clear that Lord Justice Slade accepted from his general principle cases which he described as involving a fraud on the creditors. Therefore, in those cases, motive, state of mind and knowledge are indeed to be considered. And the judge then concludes that it was a fraud on the creditors. It was known and intended to be a sale at undervalue. So that, in my submission, is entirely consistent with those principles. Lords, finally, in this canter through the cases, Macpherson. Macpherson is different in this sense, in that there was a claim at common law, which was first considered by Lord Justice Chadwick, and then there was a claim under Section 263 as well. And this was a case where it was quite clearly intended to distribute the assets of the company as if on a winding up. My learned friend has already taken your lordships to the relevant provision 687 letter F, clause 8.4. And can I just take your lordships to three short passages in this judgment? The first is at 700. And
Sorry, which tab are you in? Which tab?
Lord, I'm sorry. Tab 21.
21, thank you.
I'm terribly sorry.
Sorry, no more.
In bundle 2 of the authorities. I'm at page 700, paragraph 46.
Okay.
And Lord Justice Chadwick says, in my view, there can be no doubt the arrangement made under the 1991 agreement fails to satisfy the third of the questions posed by Mr. Justice Eve in Re Lee Behrens for the benefit and prosperity of the company. Just pausing there, rolled steel was not drawn to the attention of Re Lee Behrens. And so one finds here reference to ultra vires in the old sense. What the parties have sought to achieve, so it's about intention, by an arrangement for the payment of remuneration, is the distribution of assets as if on a winding up. As I said in an earlier passage in the judgment, the scheme of clauses 8, 9, 10 of the agreement, reading in conjunction with 4, 5, 6 and 7 is clear enough. The intention was to, in effect, an informal winding up. And then at the end of that paragraph, it's inconceivable the provision would have taken the form that it does, but for the fact that the parties wish to achieve the objective which I have identified. And then at 701, at letter B, in my view, to enter into an arrangement which seeks to achieve, not has the effect of achieving, but seeks to achieve a distribution of assets as if in a winding up, is ultra vires. As which I say, intra vires, breach of directors' duties, but fraud on the creditors. I should have said, this was also clearly a case of breach of fiduciary duty. 687F makes that clear. And there's reference to Ridge. And then at paragraph 49, in the reaching conclusion which I've expressed, it's not necessary to categorise the provision as a sham in the Snook sense, and I don't do so. It's enough to hold, as I do, that the provision can have no place in an arrangement entered into for the benefit and to promote the prosperity of the company. The parties have sought to achieve their objective without making proper provision for creditors. And, Lords, while I'm dealing with this, can I deal with with what Lord Justice Chadwick says about section 263 as well? We consider the position on two bases, and the first is at common law, and secondly is under 263, and the consideration starts at paragraph 50. And at paragraph 51, he cites the judge's decision, where he said it didn't fall within 2631 because the payments were not made in their capacity as members of the company. And then in quite a difficult passage to construe, Lord Justice Chadwick says, if I were persuaded that clause 8.4 of the 91 agreement could have had place in a bona fide transaction, I would recognise the force of the judge's view that the fact that the payments were to be made to individuals who happened to be shareholders and the fact that the amount of their payments were to be in proportion to the amount of their shareholdings did not lead to the conclusion that payments for remuneration had to be regarded as distributions within section 263(1). So he seems to be saying, if I agreed with the premise, I would agree with the conclusion it's not within 263. But he goes on, but for the reasons I've sought to explain, those facts compel the conclusion that the purpose of the parties in agreeing remuneration in the form of which clause 8.4 provides was to achieve a distribution of assets as if in a winding up without making proper provision for creditors. And then he says, the vice that seems to me is not that the agreement has made contravene section 263(1). Rather, it is that the agreement seeks by a route other than formal winding up to achieve the distribution of assets on a winding up which section 2631 would permit on a winding up, but seeks to achieve that distribution without making proper provision for creditors. In seeking to achieve that, the agreement involves the directors and acts which are outside their powers. Lord, in my submission, Lord Justice Chadwick is probably saying there that it's not within section 2631 because it didn't purport, it wasn't overtly a distribution. And certainly that's how Lord Justice Buxton seems to have interpreted it, because Lord Justice Buxton says, and this is at paragraph 57, he agreed with Lord Justice Chadwick on the common law point, but on 2631, he says that the central feature of clause 8.4 is in terms of a distribution. True, it is the distribution said to be a payment for consultancy services. The judge was correct when he said, in the passage cited by Lord Justice Chadwick, that that was retrospective remuneration. I do not agree that the phrase can easily be read as extended to the payment of future services, and as Lord Justice Chadwick suggests that the phrase can be read, the payment for future services visage is not consistent with the use of the word provided. So Lord Justice Chadwick said that the reference in clause 8.4 so this is a payment for services, could include both past and future services. But nevertheless, the purpose of the transaction was a distribution. Lord Justice Buxton says, no, it can't extend to future services. And therefore, he says, this is over the page at paragraph 59, so far as future services is, even on its face, it's a distribution. And this is 59 about the fifth line. I consider that the claim that distribution is a payment for past consultancy service is insufficient to prevent the arrangement from being what otherwise it plainly is, a distribution of the company's assets. So it's not crystal clear what the Court of Appeal's view was at the scope of 263 here. There are only two possibilities. One is that it goes no wider than the position at common law. That may have been their view. I should have said Lord Justice Gibson agreed with Lord Justice Chadwick. So one view is it went no wider than the position at common law, and that appears to be my learned friend's position today. Alternatively, it's more limited because it only applies if it's overtly a distribution. The question under 263 is the question of whether or not it is a distribution. As I say, that's either to be construed in light of the common law authorities or is to be construed in a more limited fashion. It doesn't matter from my point of view. Because it's not being suggested that it's any wider than the position at common law.
What do you say is the difficulty about paragraph 52 of Lord Justice Chadwick?
Well, it may just be me being slow, but I'm finding it difficult to understand whether... I think he is saying that section 263 does not apply.
It's the sentence beginning, the vice, as it seems to me, isn't it?
Yes.
Is the puzzle.
Yes.
Isn't he simply saying section 263 doesn't prohibit agreements, it prohibits distribution?
Yes. Well, that was the conclusion. I'm afraid it took me a very long time to come to that point. But in my submission, that is what he is saying. So he's saying 263 doesn't apply. Lord Justice Buxton is not disagreeing with that, but Lord Justice Buxton is saying that since, if one goes back to clause 8.4, 687F, no, sorry, it's not, where is it quoted?
Sorry, I haven't made myself clear. The reasoning beginning with the vice is simply, it's not the agreement which is the problem, it's the payments.
Oh, I see, Lord, sorry.
And then he's not saying that section 263 doesn't apply.
Well, it's not the agreement, rather it's the agreement seeks whether to achieve a distribution. Lord, that may be right. But certainly Lord Justice...
Perhaps what he's...
But Lord Justice Buxton clearly didn't construe it in that way, because paragraph 56, Lord Justice Buxton says, venture to add some short words of my own, because I'm minded to think the 1991 agreement on its true construction did provide for a distribution, contrary to section 263.
I can't see any inconsistency myself.
Well, Lord, maybe I'm overcomplicated.
I just wonder whether Lord Justice Chadwick's reasoning is simply confined to the particular fact that there exists in section 263(2)(d) an exception taking out of the concept of distribution, a distribution of assets to members on a winding up. So he's saying because this agreement happens to be dealing with winding up, it's not within section 263.
But that can't... But it wasn't in fact a winding up, and there weren't in fact distributable profits. So the only way, I think, of taking this out of 263 would be to say, the only argument available would be to say that it wasn't overtly a distribution, and therefore didn't fall within 2631. And that, I think, was Lord Justice Buxton's interpretation of Lord Justice Chadwick's remark, which is why Lord Justice Buxton says that he disagrees with Lord Justice Chadwick that the distribution, when it says is for consultancy services, Lord Justice Chadwick said that was both for past and future services. And Lord Justice Buxton says they can't have intended it to apply to future services. Therefore, so far as future services was concerned, it purported to be a distribution not a distribution for services, but a distribution. Lords, it may not matter.
Seems to have very little to do with the true construction of the subsection, as far as I can see. Whatever.
Well, I'm sorry I hope I was going to be helpful there, but I'm afraid I think we may have gone down a blind avenue, entirely my fault. I just want to address one other point. My learned friend says it's entirely right that everything should be looked at objectively. It shouldn't depend on the intentions and motives of people. That's not the way one judges directors. Look at the duty of care and skill. That, of course, is an objective test, not whether they believe they were exercising due care. He's right, of course, as far as the question of due care and skill is concerned. But he's wrong so far as the question of fiduciary obligations are concerned. Well, that's why I brought along Extra Sure. This is tab 15 in the Authorities Bundle 1. And it's simply a convenient way of setting out those propositions. 618 of the judgment. Mr. Crowe says at letter C, it's trite law that a director owes to his company a fiduciary duty to exercise his powers, one, in what he, not the court, honestly believes to be in the company's best interest, and two, for the proper purposes for which those powers have been conferred on him. So the question of the director's intention and the purpose for which powers were being exercised is absolutely relevant when we look at directors' fiduciary obligations. Mr. Crowe says, this is letter H on the same page, bearing all that in mind, I find nothing surprising in the proposition that crass incompetence might give rise to a claim for breach of duty of care or breach of contract, but not for breach of fiduciary duty. And at 619, he refers to a number of cases, and then letter B says those cases make it perfectly clear a director's duty is to do what he honestly believes to be in the company's best interest. The fact that his alleged belief was unreasonable may provide evidence that it was not, in fact, honestly held at the time. But if, having considered all the evidence, it appears the director did honestly believe he was acting in the best interest of the company, then he's not in breach of his fiduciary duty merely because that belief appears to the trial judge to be unreasonable or because his actions happen in the event to cause injury to the claimant. And then at paragraph 92, he sets out the law of proper purposes and notes at 93 that the third stage involves a question of fact. It turns on the actual motives of the directors at the time. So I take your lordships to that simply to show that there would be nothing unusual or surprising that in an area of company law, one needs to look at the question of motive or intention or purpose. The prime obligation of directors is to act in accordance with their fiduciary obligations to the company, and those fiduciary obligations depend on precisely those considerations. So there's nothing surprising about that at all. Lords, returning to the facts of this particular case, yes. It's clear, as I said at the outset, on the facts of this particular case, that all relevant parties intended this to be a sale transaction at market value. There was no intention, motive, or purpose on the part of any party here for the transaction to provide a benefit to Moorgarth as purchaser. It was not a dressed-up distribution to a shareholder. It was not intended to be an undervalued transaction giving a benefit to TradeGrow's subsidiary. Simply ordinary open market value transaction. So whether the question is intention, motive, or purpose, if there is any difference between those three, whether or not purpose involves looking simply at PPC's intention, which is my primary submission, or looking also at Moorgarth's intention, there's no doubt about that here. And so therefore, even if the judge had concluded that this was in fact at an undervalue and that Mr. Moore was in fact negligent, there is no way that he could have characterised this as a transaction which was a distribution to shareholders, either at common law or under Section 263. So we say simply that there are absolutely no circumstances here in which the transaction could have been characterised in this way. The second thing and final thing we say is that if we are wrong on that, and my learned friend is right, firstly, we're not very clear what it is that is said to make the difference. Is it undervalue that makes the difference? Is it negligence that makes the difference? Is it a combination of the two? Has it got to be some sort of Wednesbury test? So has it got to be simply not simply the directors were acting a little bit unreasonably, but so wholly unreasonably that no other reasonable director could have properly acted in that way? Has it got to be gross negligence, as my learned friend seems to suggest a number of times by emphasising that point, or a gross undervalue? And finally, if this were really the position, one needs to bear in mind the effect of treating transactions as being not binding on the company in those circumstances. There is some protection under Section 277 for shareholders, so far as Section 263 is relied on. But the provision at common law is completely independent of that. And it could well have the result that transactions are struck down simply because the other party to the transaction happens to own a few shares in the company. And given, if one thinks of large companies, ICI or Sainsbury's or Asda, lots of individuals will have a few shares in those companies. It's difficult to see why that should make the difference. So we say, looking at the matter more generally, there's no reason to take that effect, which could be capricious. Lordships will also bear in mind that under what was Section 35 of the Companies Act 1985, the scope of ultra vires is now very limited. The idea that the transaction can be ultra vires because it's beyond the memorandum of association has gone. So there is no overwhelming policy here that could be seen to suggest that the transaction should be treated as outside the powers. It's not that the matter will be without remedy. It will be a breach of director's duty, and that will enable the company to take action against the directors, and will allow the company to avoid the transaction unless it unanimously approves it.
You accept that one aspect of ultra vires that does remain is the prohibition on making a distribution to shareholders. So the fact that the memorandum type ultra vires is gone is irrelevant.
Yes. I said there is that. Yes.
Can I just ask one question? Would there have been anything to preclude Tradegrow, Moorgarth saying to Mr. Price, you're not going to get 100% of PPC unless you agree to sell PPs, unless you agree effectively to credit us 4 million in the transaction, so that we pay a net £63,000, as if you'd given the promised counter indemnity and we were releasing that? Would there have been anything illegitimate about that?
No.
And just a matter of interest, bearing in mind the memorandum that was recited in the judge's judgment at page 21, paragraph 26, which recites, apparently this is a revised version of minutes, which recites that it had been agreed that PPC had given a counter indemnity and that PPC was now being released by Tradegrow from that indemnity, effectively giving the basis for a 4 million credit in the transaction. Bearing in mind that memorandum, would you just satisfy my curiosity as to why estoppel as to the existence of counter indemnity and indemnity was never relied on, apparently?
It was obviously a matter we considered, Lord.
Yes, I see. Just seems to me if parties have as the basis of their transaction minutes which recite something, it's rather difficult for them later to come along and say it doesn't exist.
Look, I'm sorry, I cannot remember offhand why we didn't. Obviously, if it was a guarantee, there'd be a problem with Section 4 of the Statute of Frauds. And there's
It's not a guarantee, though, it's a counter indemnity.
Yes, if it was an indemnity, not a guarantee, that wouldn't be an issue. There might be an issue about promissory estoppel used as a sword rather than a shield. I'm afraid I can't remember offhand why that point was not pursued. Unless I can assist further, my lord.
Thank you. Mr. Fowler?
Briefly, my lords.
Yes.
The question is a transaction to be characterised as a distribution and therefore to be rendered ultra vires in the absence of there being distributable profits and there therefore being an unlawful distribution? And the common law and Section 263 march in tandem. And it is obvious that it's not every payment which is made by a company without distributable profits to a shareholder is to be so characterised, neither in the common law nor as a matter of statute. The payments may, for example, be made to the shareholder in a completely different character and therefore not be appropriate to be described as a distribution to a shareholder. Now, my learned friend presses the terminology fraud on the creditors. Lord Justice Slade's obiter comments in Rolled Steel. And the reason that he does that is because it has a lovely subjective element to it. It sounds like an intention. It sounds like a bad motive. It sounds like the lack of good faith. But what is meant by a fraud on the creditors is an unlawful distribution, i.e. a distribution which is made otherwise than out of distributable profits, because the whole point about the maintenance of capital is to protect the position of creditors. And you can only take money out of a company if you're a shareholder, if, when you're doing it as a shareholder, if it's your money to take, i.e. there are profits which are distributable. Now, can I go back briefly to Holt Garage, please? And to pick it up on page 1024, and just so that your lordships note the reference to at the end of the first paragraph on 1024 to there being no suggestion of mala fides in that case. And again, that's at the end of 1024 when his lordship is dealing with the Charlesworth's Council's submissions. And again, on page 1040, between letters E and F, bona fides is conceded, specifically there set out. Now, what I then want to concentrate on is pages 1043 and 1044. In the Court of Appeal, one of their lordships described Mr. Justice Oliver's judgments, or certainly the judgment in Holt Garage, as symphonic, in that there are themes to which his lordship came back to through the judgment. And of course, his lordship, an impeccable source, my learned friend, accepts the correctness of Holt Garage, but just says it means something slightly different to what I say it means and what it does mean. If we look first of all at page 1043, there's a reference to bona fides, which was picked up in Aveling Barford. And what his lordship says at B is, I do not, however, think that bona fides in the sense of absence of fraudulent intention and genuineness, are necessarily the same things. Not suggested here any intention to defraud, but that can't be conclusive. As Master of the Rolls Lord Jessel remarked, to say that something is done bona fide is not the same thing as merely to say that the act had no intention to commit a fraud. The real question is, were these payments genuinely directors' remuneration? If your intention is to make a gift out of capital in the company, you don't alter that nature of it by giving it another label and calling it remuneration. Now, what my learned friend then went to the end of the paragraph on page 1044 at F. In the absence of any evidence of actual motive, the court must, I think, look at the matter objectively and apply the standard of reasonableness. Now, here, what does that mean? What his lordship means by that in my submission is in the absence of any actual bad motive, i.e. an intention to make a really culpable intention to make a payment out of capital in the full knowledge that they haven't got the money to do so.
Why do you say that?
Well,
doesn't he mean in the absence of any express evidence as to what he was trying to do?
yes.
Because the issue was he actually trying to pay remuneration? Or, looking at the bottom of 1043,
Yes.
was he trying to make sure that, was the intention to make sure that the wife continued to get out of the company what she always had,
Well,
on the basis that calling it remuneration would make everything all right?
I think my learned friend's approach to this was he was saying there that that if you have a bad motive, then that obviously renders something an unlawful distribution, and that chimes with his list of points. But the reason that this case is important is that it doesn't really work terribly well, because let us assume here that there was indeed a motive to pay remuneration to Mrs. Charlesworth, and that was a good motive, that they thought that she was worth the money. And indeed, when one looks at this, one looks at just a little bit lower between H and I cannot regard the payments made to Mrs. Charlesworth in excess of this weekly amount, however well-intentioned, as being anything more than. And of course, what they had done is they had specifically voted these amounts to Mrs. Charlesworth as remuneration, but they'd done so in a totally bona fide way without any bad motive or anything like that. It's just that in all the circumstances, when you look at the top of earlier on in page 1044 and the reference to George Newman case just at C, or just above, just below B, it doesn't authorise what, for want of a better term, I may call pure gift, however described. Although it's come out of divisible profits, the shareholders can, as Lord Justice Lindy said in George Newman case, do what they like. Can't, I think, be right that where a payment is made out of capital, which is described as remuneration, but which is so manifestly beyond any possible justifiable reward for that, in respect of which it's allegedly paid, it has to be treated as valid in whole, simply because a part of it, which may be difficult to quantify, can genuinely relate to some service or office. And that's the point that my Lord Mance picked up about the pro tanto. And so in this case, Mr. and Mrs. Charlesworth were, to all intents and purposes, genuinely voting and intending to vote Mrs. Charlesworth remuneration. That's what they voted on in general meeting and so on, and that's how they described it. And they didn't describe it in a dressed-up way. And this was a point that my Lord Clark made. Dressed up is unfortunate because it has with it a sort of an air of culpability. Obviously, if you're dressing something up, it means that you're trying to give it intentionally the wrong label. It's better just to talk about a label not being conclusive, which this case does. So they genuinely pay remuneration, but the court, nevertheless, objectively looks at what remuneration is reasonable for Mrs. Charlesworth, and the bit that is not is a payment out of capital and has to be returned as an ultra vires payment. And that's the conclusion that's reached here. So when one's talking about motive, his lordship is for all one might know, the motive of Mr. and Mrs. Charlesworth, certainly their intention, and it was entirely genuine, no bad faith, was to pay this lady remuneration. That was what they intended to do, and that's what they hoped to do. But it didn't work.
You can't put it as high as to say that the court looks at what is reasonable, because of Mr. Justice Oliver's statements about the court not considering what is wise. At the very most, surely, you can suggest that it might be, a test might be one of Wednesbury unreasonableness, if it's so manifestly beyond anything that anyone could sensibly call remuneration for what was done then.
That is indeed right, because at little c on 1044, that's the way in which his lordship approaches it, manifestly beyond any possible justifiable reward. So I must seek to assure my learned friend here that we're not seeking to, upset, make company directors' lives any more difficult than it is already, because when one analyses the circumstances as to whether a particular transaction is to be characterised as a distribution and be rendered ultra vires and unlawful because there are no distributable profits, I've accepted. It's not a question of strict liability and, it's a payment to a shareholder, therefore it must be a distribution. No, it has to be characterised as a distribution to somebody as a shareholder. And if you're talking about something like remuneration, a great deal of attention will be paid to directors' managerial decisions and shareholders' managerial decisions, and the court won't seek to run a company. But what it will do is it will scrutinise and then conclude on an objective basis that if something has gone manifestly wrong, if the sale, and this is where my learned friend says, we're a bit unclear about the test, well, the sale has to be at a gross undervalue. The remuneration has to be manifestly beyond any possible justifiable reward. But the fact that Mr. and Mrs. Charlesworth didn't think that it was, and they thought that she was entitled to remuneration totally honestly, because it couldn't be made clearer in this case, no bad motive, all the rest of it, doesn't mean to say that it is not to be scrutinised objectively, which is exactly what his lordship did. And that really is the end of Hawk Garage, as I say, from an impeccable source, and it's exactly in that context which Hawk Garage has been referred to in Aveling Barford, and of course it was Aveling Barford, because perhaps Hawk Garage is not such an accessible case, and Rolled Steel's certainly not a very accessible case, but Aveling Barford, when it pulled the strands together in a very clear manner as to unlawful distributions and there being ultra vires, really brought this to the public gaze slightly more, which was why the Aveling Barford principle became so well known and featured in the CLR. The last point that I would wish to make is in relation to what my learned friend said last, in relation to the duty of care, and he accepted that a director's common law duty of care was subject to objective assessment, and we know that from the Dejan case at tab 13 of volume 1, and this is the bit that I actually recited in the statement of case, because Mr. Justice Hoffman said that a director's common law duty of care, and of course being a common law duty of care, one imagines that there would be an objective standard of reasonableness in any event to judge that duty. But in the Dejan case, tab 13, on page 563, a director has to be judged. The duty of care owed is accurately stated as conduct of a reasonably diligent person, having both the general knowledge, skill and experience that may reasonably be expected of a person carrying out the same functions as carried out by that director, but also the general knowledge, skill and experience that director has. So if you like, there is, as I was submitting this morning, an irreducible minimum of objectivity, But a director's position may be made worse by the actual knowledge and experience that he has. So, for example, dealing with a problem within a company which is financial, if you're an accountant, you may be in a worse position. Indeed, my Lord Mance may remember this from years ago in a case called Dorchester Finance and Stebbing, in which this whole area, which goes back to old law, the Lagunas nitrate case in the 19th century, features. Then Maloney, so as it were, at the bottom level of directors' duties, which is the common law duty of care, it's their objectivity. Then Maloney Friend said, by reference to Extrashaw, which is, I'm glad why I brought down Mr. Justice Lewison, when it comes to fiduciary duty, which is a higher level of duty on the part of somebody in a fiduciary position, akin to a trustee, oh no, at that point you don't judge it objectively at all. You simply judge it pursuant to what that person honestly believes. Well, that's simply not right, because if you honestly believe that you have power, or you honestly believe you can do something, or you honestly believe you have authority, doesn't mean to say that you actually do. And then, going up the scale again, in relation to one of the most fundamental principles, and that is the maintenance of capital, whereby shareholders who control companies are simply not entitled to procure the payment to them of money which is not theirs and then somehow exonerate that by ratification. He says, no, again, it's all entirely subjective. So the worse the crime, the easier it is to get off it, and that's just simply not right. So, my lords, those really are our submissions.
Thank you. The court is grateful to counsel for their submissions and will reserve its judgment.